is a $1,500 fine, time and money to run, showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? I'm sorry?
Yes.
All right, this has not been a plea bargain agreement, so you do have a limited right to appeal.
Welcome back, folks. Today's courtroom drama features Amethyst Garcia, a woman with a troubled past seeking another shot at redemption. The stakes: a hefty prison sentence, a possible fine, and a plea that could either give her a second chance or seal her fate. The courtroom is about to be rocked by shocking revelations about her criminal history, the emotional plea of her attorney, and the judge's ultimate decision. Buckle up, because this is one case you don't want to miss. Who's gonna get justice here, and will Garcia turn her life around or face the consequences of her past mistakes? Stay tuned.
Any pleas were entered?
No, Your Honor.
And State, are you going to proceed with the motion to revoke as well?
Yes, Your Honor.
All right, so we'll start with the motion to revoke for her to enter whatever plea she wants to enter.
Yes, Your Honor.
And Diane, I'm going to call both cases at the same time. Court is calling 2021 CR 2958 and 2022 CR 8569, State of Texas versus Amethyst Garcia. Can I have?
And here we go. The court begins with two cases, both involving Amethyst Garcia. A moment of clarity as we hear the terms of her plea deal: 5 years in prison and a $1,500 fine. The stakes are high, but this plea could be her chance to get back on track. But with a criminal history that includes prior probation violations and new charges, will the judge be lenient? Let's find out.
$100 fine. State is silent on your application. They're taking in consideration NIMAG number 688702. Have both parties had a chance to review the PSI report?
Yes, Your Honor. With my understanding that the cap was at 4 on that sentence.
No, I'm just reading what's in the.
I understand it's cap at 5. 5?
Yes.
Okay.
All right, have both parties had a chance to review the PSI report, State?
Yes, Your Honor.
Defense? Any objections to the PSI report, State?
No objection, Your Honor.
Defense? And then, Ms. Garcia, I'm going to show you what's entitled Motion to Revoke Community Supervision and States.
Now, the motion to revoke Garcia's probation takes center stage. The state's got evidence of a serious violation from back in June of 2022. She's accused of possession of a controlled substance with intent to deliver. Ouch. This violation could lead to even harsher consequences for Garcia. Let's pause and think about the impact of this. When you break probation, you risk everything: another shot at freedom, lost.
22 for a term of 5 years.
Yes, none.
All right. State.
Yes, Your Honor. Actually, Your Honor, on violation condition number 1, for the June 9th, 2022, the state would like to orderly amend it, striking the language W/I-D-E-L, which stands for with intent to deliver, to the court.
Any objection?
No objection, ma'am.
All right. Ms. Garcia, do you understand your attorney has 10 days to prepare for trial? Did you understand that's a substantive change to the motion to revoke?
Yes.
Knowing that, do you still wish to continue?
Yes.
Thank you. All right. We've lost video. Okay. All right. State?
Yes, Your Honor. Violated condition number 1 on or about the 9th day of June.
Here comes the emotional part. Garcia's attorney passionately defends her, talking about her struggles, her grandmother's death, losing a brother, and the mental toll it's taken on her. But is that enough to sway the court? The judge is hearing these tragic stories. But will the emotional plea outweigh the severity of the law? Is the defense asking for too much? We'll see.
True to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. I'm assuming there's no agreement on the motion to revoke?
That is correct, Your Honor.
All right. And the state is silent on 2022 CR 8569. And that cause number, defense, do you have any witnesses?
No, Your Honor.
All right, then the court will hear argument.
Well, on the, are you saying for the application for probation?
Yes.
Yeah, the application for probation. Now, when we were trying to negotiate all of this NPR and everything, so my understanding is, and of course right now I'm saying it's different, but my understanding is that the NPR agreement for the or punishment would be to run concurrent or to run together with the case that she plead on. So that's what, on that new case, Your Honor, we're asking this court to give her another opportunity. Now, she did not comply with her probation. In fact, she, as Your Honor can read, she didn't even start her probation. She didn't show up for orientation or anything like that, which caused the warrant and everything to come in. Now, she realized she's been in jail since November of 2022. She realizes that this has to stop. And she picked up a new case. It doesn't get any better, Judge, it gets worse as you go along. However, I'm asking this court to give her another opportunity. And why should you give her another opportunity on probation is because I think that she realizes that this has to stop. She had a death in the family of her grandmother last year. That was her mother figure. She lost a brother who also contributed to her mental state, which made her do bad judgment. So we're asking the court to give her the opportunity to go on probation, do things right, go back, because she's got 5 daughters to go home to, which are in the hands of their family. She has a father that is there, that is willing to support her, and she also has a job that's waiting for her when she gets out. Yeah. So we're asking the court to give her the opportunity. It's a second opportunity. I know that the facts in her case don't warrant it, but we're asking the court to do so. Because I had long conversations with Ms. Garcia, and I can tell the difference in attitude as to what she has to do in order to continue on with her life. Now, the TAP evaluations are recommending SAP, and SAP right now is, I know it's a long waiting list, and it'll be maybe a few months before she goes to SAP. But we're asking the court to follow the other alternative, which is the outpatient treatment, and put as many requirements on her for her probation to do the outpatient treatment. That way she can go to work, she can go take care of her children, and she can prove to this court that she, and I'm not saying she learned her lesson, I'm just saying she has learned that she has to stop. That's the only words I can come up with. She has to stop. She has to grow up and be there, a parent for her children. And I'm asking the court for probation.
All right. So anything you wish to say, Ms. Garcia? All right, you want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand. You're going to have to make sure you keep your voice up. State your name for the record.
Amethyst Garcia.
All right. What would you like to say?
That I apologize, that I was in the wrong, that I used an excuse when it's not an excuse, and I've acknowledged that now. I'm not saying that, oh, no, that's the time. No, I know that I have to do what I need to, and I do have 5 daughters, 9, 8, 7, 6, and 5. And I need to be there for them. I do have a job lined up. I do have support from family, and it's time to go on with my life and to carry on and do what I need to do as a woman, as a mother, and what I need to do.
All right. Ms. Garcia, I'm looking at your criminal history. And sometimes people are learning their lessons, but your criminal history is not good. And when I look at criminal history, I'm not necessarily looking at it to say, oh, this person is a bad person. I'm looking at it to see, has there been any type of intervention?
The judge is breaking it down now, and it's getting real. She's not just looking at Garcia's past offenses, but what those offenses mean for society. Is probation enough to give Garcia a second chance? Or is her history of failed interventions a clear sign that probation is no longer an option? The judge isn't holding back. She's being straight with Garcia, laying down the harsh truth.
And I don't think probation is appropriate for you because of that. And because of other things that are in the PSI report. the fact that I previously had you on probation to work with you. And I think any defense attorney in this courthouse, in this courtroom will tell you that when I put people on probation, I'm hoping that they will be successful, and I give them conditions to have tools to be successful. And I always ask people when I place them on probation, I always ask them, is there anything else they need from the court to be successful? And what you've done since you've been on probation is not report. You just picked up new charges, and I can't have that. All right, the court is going to sentence you to a $1,500 fine, time and money. I'm sorry, cause number 2022 CR 8569. The court will sentence you to a $1,500 fine, time and money, and run concurrent. This will run concurrent with 2021 CR 2958. 5 years in the prison. Take in consideration night mag number 688702. Give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Because this is a plea bargain agreement, because I followed your plea bargain agreement and you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Now, if you would like, because I do see the TAP evaluation, they're recommending that you do inpatient treatment. If you would like, I could recommend you for the therapeutic community. It is a drug treatment program. I cannot force them to put you into it. All I can do is recommend it, and then you will have to recommend it yourself. It does not increase the amount of time that you're in custody. Would you like to be considered?
No. We're being in custody if he wants to. Don't do it. Would you explain again, Your Honor?
All right. So the therapeutic community, I do not have jurisdiction to force them to place you in the therapeutic community. The therapeutic community is a program at the prison that will hopefully help you with any drug issues you have. If you are accepted into the therapeutic community, it does not increase your prison time. So, for example, in this case, you've been sentenced to 5 years prison. If you're in the therapeutic community and you do not complete it, they're not going to say, oh.
And here we are after all the back and forth, all the pleading, the judge has made her call. Garcia is sentenced to 5 years in prison, but with some credit for time served. The case concludes with a ruling that's not exactly what either side hoped for, but it's a clear decision. No probation, but a shot at rehabilitation in a therapeutic community. This decision shows how the court balances the past with the potential for change.
Yes.
All right. And we'll do a request for therapeutic community. All right. Next, we're going to move on and cause number 2021 CR 2958. The court found violation of condition number 1 true. The court will sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 8569. There's to be no contact with Antonio Reyes, Reyes. And there is a $1,500 fine, time and money to run concurrent. And that cause number I'm showing you, and I'll request the therapeutic community. And that cause number I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it? I'm sorry?
Yes.
All right, this has not been a plea bargain agreement, so you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion.
This case shows us the tough reality of the justice system. Despite a powerful emotional plea, Garcia's criminal history and past violations were too much to overlook. The judge's decision is a reminder that second chances are hard to come by when you continuously fail to take responsibility. So what do you think? Should Garcia have been given probation, or did the judge make the right call? Let us know your thoughts in the comments below. If you were in Garcia's shoes, would you have handled things differently? And don't forget to hit that like button, share this video with your friends, and subscribe to our channel for more dramatic courtroom breakdowns like this one.